you for joining us today on today's PowerUp webinar, Employer-Focused Questions for the Texas Workforce Commission. We know this is a difficult and uncertain time for all of us. The Chamber is trying to do what we can to provide information and resources to our member businesses. We are also grateful for our partner chambers who are each doing great work serving the business community. For today's program, we have the following sponsors. Kim Flores is the Vice President of Human Resources at vcfo and our moderator for the day. vcfo is an Austin headquartered finance and accounting and human resource consulting firm. Kim leads vcfo's efforts in recruiting, performance management, philanthropy, training, compensation, and engagement. In addition to managing internal HR activities, Kim enjoys partnering with vcfo's managing directors and consultants to aid in the delivery of HR services for vcfo's broad client base. Kim?
Thank you, Quillan. We are so pleased to have the following people join us today from the Texas Workforce Commission. Angela Ford is the manager over special claims. Angela has been with the Texas Workforce Commission for 31 years, with most of her experience with the unemployment insurance program. She is the federal program coordinator for Texas, where she coordinates with other states and Department of Labor on federal claims filed with Texas. Jerry Ramos is the director of the Texas Workforce Commission's Office of Investigations. He is responsible for the Labor Law Department, Benefit Payment Control Department, Fraud Prosecutions Department, Program Investigations, and Internal Investigations. Jerry has been with the Commission for 32 years. Lachey Lindsay is the Deputy Director of Unemployment Insurance Division. After graduating from Baylor University, Lachey began working for the Commission and has been with the Commission for a little over 31 years in the unemployment insurance program. Thank you all for being here today. During this unprecedented time, employers are having to make the difficult decisions about their workforce. We appreciate these speakers from the Texas Workforce Commission making themselves available to answer employer questions about different programs and processes at the TWC. We received some questions from registrants regarding the FFCRA Families First legislation, including the new paid leave laws. We will not be answering those questions on this call because they are not in the TWC jurisdiction. Questions regarding paid leave and FFCRA are governed by the Department of Labor. We have a lot of questions that have come in, so let's get started with questions for the TWC. So our first question is, I've heard that even independent contractors and self-employed people can get unemployment benefits. So how will that affect unemployment insurance rates, as those cases don't typically pay into the unemployment insurance?
Good afternoon, this is Lachey Lindsay. Yes, for independent contractors and self-employed individuals, they can apply for benefits. And as far as the unemployment insurance rates, the state system is for covered employees. Since those people are not covered employees, they would actually be paid out of the federal dollars, which is the $600 one that you've heard about through CARES.
Thank you. Our next question says, can general partners or co-owners of businesses who don't get paid W-2s, sorry, my questions just shifted here. Okay, I'm gonna, oh, here we go. But they are guaranteed payments and or profits claim unemployment because the businesses have been shut down by the city or state order. How? Similar to how self-employed people do get it?
Yes, that's exactly how they would apply, the same way that self-employed individuals do. You go ahead and complete the application. You can go to our website or give us a call and fill out a claim for unemployment benefits. It will initially say that monetarily the individual does not qualify, but then we will contact them to get additional documentation such as check stubs or their tax return, anything that they have that shows their profits from the previous year, from 2019.
Great, thank you. Our next question says, I've heard that if businesses are shut down due to a city or state order, the unemployment claims won't be counted against those businesses' unemployment insurance. Is that correct? If so, is that only for the period when the businesses are closed? What about afterwards when the lingering effects of the economy, of people still being scared to go out, cause that business to reduce hours or lay off workers? What about businesses that aren't forced to close 100% like restaurants? A lot of questions within that question.
Yes, I think they're asking about their unemployment tax rate when they say our claims going to count against them. For the state unemployment tax rate, employers' accounts are being protected. So for covered employers, it will not affect their unemployment tax rates, even if the business has opened back up. Because I see it says will it only be for the period the businesses are closed. An individual can file an unemployment insurance claim, and that claim is in place for a year. So if the person was filing longer than the time that the business was open, the employer's account will still be protected for the life of that claim. And that's on state benefits that are paid to an individual.
Thank you. How will the unemployment insurance rates be affected with so many workers claiming unemployment at this time?
Well, again, it will not impact their state experience rate because their accounts are being protected. But long term, there is a self-adjusting mechanism in the calculation for state benefits. It's called our replenishment tax. It's a much, much lower tax, and it's more of a socialized cost. So long down the road, there could be a small impact to the replenishment tax rate, but not to the individual experience rate that employers typically would be referring to. Now, as far as FUTA tax rates are concerned, that's on the federal side, so I wouldn't have that information.
Thank you. Here's a process question. So if a contract worker is entitled to unemployment, is the same confirmation process needed from employers as they do for the W-2 workers?
Yes. When the claim is filed, we automatically send out a notification to the last work that was performed, regardless of whether that work was for an employer that you had payroll taxes or actually W-2 wages with. We're still going to send that notification to the last place that the person worked. And we ask that employer or that company to send that information back in, and please notate if the layoff was due to COVID-19 or if it was for some other reason. That could be the case. Some separations now could not be related to the coronavirus. So it is helpful if the employer would indicate on there the reason.
Thank you. Here's another question that has multiple questions within it. So I've read about the $600 per week additional unemployment that is available to all workers, including 1099 contract employees. I have a few questions regarding this. A, I'm applying for the Payroll Protection Program loan. If I get that, I need to maintain payroll, and it looks like payment to contract workers qualifies for it to be forgivable. What if the full-time paid per week is less than $600 or less than $600 plus regular unemployment amount and the workers refuse to go back? Did they quit in that case? Do they still qualify for unemployment benefits, including the $600 additional? What if they're 1099 workers who can come and go as they please? So what's defined as quitting there? What does the verification process look like in that case?
That is a mouthful. For the $600 additional benefits, first let me say that those are federal benefits. So those are paid in addition to regular unemployment benefits. Now for workers that are 1099 workers that don't qualify for regular state unemployment benefits, the only one that they would get would be the $600 federal pandemic benefit. Let me read a little bit of that question. As far as what will affect the payroll protection program, that's not going to fall under Texas Workforce Commission. You would have to actually contact the Department of Labor. Now, as far as whether or not a worker refuses to go back to work, is it considered a quit? We would need to investigate that on a case-by-case basis. For example, some employers may give an employee a definite return to work date. If they did not return back within that time period, we would probably view it as a quit. If the person was actually laid off and then the employer called them several weeks later and said, we're open back up, a job is available, we may look at that as a job refusal. Whether it is a job refusal or a quit, it is still something that we would want to investigate and make a ruling on. So we would ask that, again, that the employer or the company, please send us notification when those type things happen so that we can complete an investigation. Let me see, was there anything else in that question that I may have missed? And the verification process, if I didn't make it clear, it is the same whether the worker is 1099 or W-2, as far as the information that we get from the last work that they performed.
Great, thank you. What is the shared work program and how does it operate?
Hello, this is Angela Ford. I'll go ahead and take that question. The shared work program is an alternative to an employer laying off their employees. It is a reduced hour program. The employer applies for the shared work program that the Texas Workforce Commission manages. Once their application is approved, their employees have to be working at least 24 to 36 hours based on a 40-hour work week. That is a 10% to 40% reduction in a 40-hour work week. Once the employer files the applications approved, their employees will then have to go on to our unemployment benefits services site and file an application indicating that they want to participate in the employer's program. Once they do that, then every week or every 2 weeks, the employer will go back into our employer benefits services website and report the reduced hours. In order for the individuals to be paid benefits, as I previously said, they would have to work between 24 to 36 hours on a full-time basis. If they were working 40 hours, they must be available and accept any work offered to them by the employer. If they refuse any work, then the Texas Workforce Commission will determine if they're eligible for payment. But it is definitely an alternative program to having a layoff and is for a reduction in hours.
Great, thank you. I'm gonna go, we've had some questions come in on the call. So I'm gonna scroll down. Beth Paul has asked a question. Some of my staff members who I employ as a W-2 employee are signing up as 1099 independent contractors to sell other products not related to our business. If they do this, are they in violation of their unemployment benefits?
Did you say they're signing up? Can you repeat that one more time?
Sure. So they are signing up as 1099 independent contractors, I'm assuming with another entity, to sell other products not related to this company's business? If they do this, are they in violation of their unemployment benefits?
If an individual is receiving unemployment benefits, they have to file a continued claim with us every 2 weeks. When they file that claim with us, that's what generates to them the payment to be released from us. But before that payment is released from us, there is a series of questions that the individual must answer. One of the primary questions is, did you work or perform any type of work for anyone or have any type of earnings? They are to report any work or earnings performed on that question. Any work that they perform or earnings that they earn actually would be deducted from their unemployment benefits. We often do see individuals that will have some part-time work, and that's fine as long as they report it so that we can make that calculation and deduct it from the benefits that we would be paying.
Thank you. We have a couple questions about the mass unemployment claim that employers can make. So could you maybe give a little summary of what that is? And then we have a specific question after the summary.
The mass claims program is a program where an employer can submit a partial claim for their employees. The benefit of this is that the employees do not have to go on to our website or call our telecenter to file an initial unemployment claim. The employer gives us the preliminary information to set up sort of a batch claim, where it is a partial claim that it takes the employee to activate it. If the employee wants to activate the batch claim that was filed by their employer, then every 2 weeks they will sign on to either our website or go to our teleservice system, which is an automated payment system, and request those payments. Once they do either sign on to the website and do a payment request, or do our teleserve system and do a payment request, that activates the batch claim that the employer filed for them. If the employee decides that they do not want to file for unemployment, after a period of time that gives them enough time, usually between 21 to 28 days, gives them enough time to file their claim, the claim that the employer filed for them then becomes inactive. So it doesn't stay out there forever, but it is a way for them an employer to stop employees from having to go on individually and file a claim. The benefit to the employer is stop sending out a notice. They don't get a notice on every claim that's filed. Them filing the mass claims is their notice to TWC that they are saying this person was laid off for whatever reason, either permanent or temporary.
Thank you. So the question regarding mass claims was, if we submitted a mass claim for our employees, are we responsible in reporting their weekly earnings, or is that between the employee and the TWC? And this assumes that the business is not operating and there is no work for them to do.
On a mass claims, once the employer sends in the submitted spreadsheet, either on our employer benefit services or during this time, a lot of times our employer benefit service has not been able to accommodate everyone submitting their spreadsheets. But once the spreadsheet is processed, whether or not by our employer benefit service or by our mass claims department, the employer then has no other jurisdiction on the claim. The individual employee takes over that claim and files just as if they filed the claim themselves by reporting everything every 2 weeks.
Thank you. This is a question that's coming from someone who had an unemployment claim, but I know that businesses sometimes get these questions too from people who are trying to apply for benefits. Let's see. Sorry, my screen just shifted again. All right, let's take a different question for now. Renee Pettijohn had a question. Is the realtor process to claim unemployment any different since they are 100% commission-based income?
No, it's no different than any 1099 or self-employed individual. You would still fill out the unemployment claim, go through that process online or by calling us, and then we will contact you to get additional information. It'll probably be saying, can you send us your proof? And that would be things like, well, for that individual that you just described, it would probably be the tax return.
Thank you.
And that tax return does not have to already be filed. So even though it's the tax return for 2019, if they have not filed it yet, as long as they have completed it, we can still use that information.
Okay. Dana Small has a question. If we get approved for the shared work program and work picks up and becomes available, can we cancel the program or modify it?
Yes, the program allows you, the program is very flexible. It allows you to come on and off the program. A shared work application is good for 1 year. So if work picks up, you no longer need the shared work program, you can return to our employer benefit services and terminate your application.
Great. There's another shared work program. We have applied for the TWC shared work program. What is the timeline for approval, assuming there is an increased demand? Will hour reductions be honored and paid by TWC under this program while the application is being processed?
Currently, based on the volume that we are receiving for the program, our turnaround time is 7 to 10 business days. We have been approving the plans as of the date that the employees start having reduced hours.
Okay, great. Patsy Harnage has a question. My staff is getting unemployment. I'm signed up to take care of COVID-19 children. Can my employees work as volunteers?
Repeat that one more time, I'm sorry.
Sure. So her daycare is closed to regular childcare, and her staff is getting unemployment. I'm signed up to take care of COVID-19 children. Can my employees work as volunteers?
Hi, this is Jerry Ramos.
I'm thinking, and they're not going to be paid anything, right?
It doesn't look like it if they're implying a volunteer status.
I'm sorry.
Yeah, in that situation, hi, this is Jerry Ramos. If an individual volunteers for a for-profit business, it's not technically legal under the Fair Labor Standards Act. You can only do that for nonprofit organizations. If an individual is volunteering where they would be displacing somebody else that would normally be doing the job, it would also be illegal.
Okay. We have another question. If an employee makes a false claim that they have COVID-19 and we terminate the employee for this, will the employee still be able to receive unemployment?
Any separation that where a person has been terminated has to be investigated by the Texas Workforce Commission.
It's not just an automatic.
Okay, here, James McClurg has a question. Does the chargeback protection work the same for reimbursing employers? If so, do you know if it will all be covered or what percentage the reimbursing employer will have to cover?
It does not work the same for reimbursing employers, unfortunately. The chargeback protection is for covered employers that have paid ongoingly into the trust fund, and they've paid payroll taxes every quarter on all of their employees. Reimbursing employers do not pay into that fund. They do not pay payroll taxes every quarter. They pay only when a claim is actually filed. At this time, there is not a protection in place for reimbursing employers. I know that it's probably something being looked at, but to our knowledge, it's not something that's been passed yet.
Okay. Richard McVeigh has a question that I'm sure a lot of people have right now. Many times the TWC sends notices out to employers via the mail asking for information. So Richard's question is, will I get penalized if I miss the appeal dates in the letters that are sent out for laying off my employees due to the closure of my business for COVID-19?
They are encouraging, the agency is encouraging all employers. One of the options that we have with employer benefit services is to get electronic correspondence, where the correspondence can come directly to your inbox. They are telling all employers to try to do that. If they are unemployed due to the COVID-19, since your account will be protected and is considered a layoff, whether you return the notice or not, you're not really required to return the notice of unemployment insurance on a temporary or a permanent layoff.
Can I just add, it's always in your best interest, though, to return that notice, because down the road that protects you, keeps you being a, what is it called?
Interested party.
That's right. It keeps you as an interested party through the life of the claim. So if you had some additional things that were to pop up during that life of the claim, if you didn't respond to that initial notice, then you're not considered an interested party. So it's always good to send the notice in to preserve your appeal rights.
We have a new question that just came in. Should 1099 workers list their place of work as the employer, such as like Uber or a salon, or should they list themselves as the employer?
In most situations, they list the place where they worked as the last employer.
Okay, here's another longer question. So claimant applications submitted to TWC with a reason of permanent layoff should have been submitted with the disaster reason, as the business has temporarily closed, I'm assuming because of COVID-19. How do I go back to TWC and ask them to reconsider the claim as disaster related so the employer account is not charged? Included in the work separation response to TWC, I had noted disaster next to the permanent layoff on the claim's first page, but TWC did not change the reasoning and therefore were being charged. Who can I contact?
If the person, when they initially signed up, indicated that they were a part of a COVID-19, because that is one of the questions asked on any time that they filed, either by telephone or by mail, by the internet, I'm sorry. If they then go to the application, they put permanent layoff instead of the disaster, then at that particular time, if you are being charged, then you would need to contact the 1-800 number that's on the notice of unemployment insurance, and you can speak to a representative and you can let them know that you had responded back that the person was out of work due to the COVID-19, and yet your account is being charged, so they can look into that. If you do not hear from them, one of the things that you should definitely do is file an appeal to that decision. You want to protect your appeal rights in case that person someone cannot get back to you within that 14-day guideline for filing a timely appeal.
You mentioned calling into the 800 number. I know that there are a lot of people probably trying to contact you right now. Are there other ways of reaching? Are there, can people send information to you via fax, email, or are there any other ways other than your 800 number to reach out?
Yes, our phones are overwhelmed, and we are adding many lines as we possibly can. We've been working with AT&T to get several hundred additional lines added that will feed to that 1-800 number that you're referencing. But please send it to us via email to uiombudsman@twc.state.tx.us. That's UIOMB like boy, UDSMEN at twc.state.tx.us.
Great, thank you. And for those of you who are in the chat function, we have put that email address there. Okay, we have a couple questions that have come in through the chat. So one is coming from Kathy Guthrie. If an employee has worked in Texas and moves to another state for remote work and we decide to do a work share program, can the employee receive unemployment benefits in Texas for some period of time? And if so, how long?
With the shared work program, the shared work program is set up based on the employer filing the application and listing that employee as a participant. At that particular time, the wages that are used to determine their weekly benefit amount to which they can be paid their 10 to 40% against is based on past earnings. So it's when the account is set up, if they move somewhere else after that, and I wasn't sure whether you meant they moved there to live or to do work.
It sounded like to do work. I'm not 100% sure.
As long, okay, if they move there to live, keep in mind with the shared work program, they have to be physically working between 24 and 36 hours, or if they are commuting from where they moved to come back to your business to work the 24 to 36 hours, then it doesn't matter to the Texas Workforce Commission where they live at. But if them moving causes them not to be able to work between 24 and 36, they will no longer be a participant in your program.
Great. Thank you, Kathy, for making that clarification for us. So another question about the shared work plan. How do we know if our shared work plan was approved or not?
You get an email from the Texas Workforce Commission Shared Work Department advising you that your plan has been approved. We also send you the user guide that you will use to file your weekly or bi-weekly reduced hours, and also an information packet telling you the do's and don'ts of being on the shared work program. So you get multiple emails from the Texas Workforce Commission.
Great. So here's another shared work program question. Our employee proactively reduced pay by 20 to 25% for exempt salaried employees and reduced work hours for hourly from 40 to 32 in a work week. Would we be eligible for a shared work program? There's a question that asks, is your request for a shared work plan an alternative to a layoff? For us, we're doing pay and hours reduction to avoid future layoffs. Would we be eligible for the program? And would salaried exempt employees be eligible since they didn't have a work reduction, just a pay reduction? We're trying to figure out if our employees are eligible for the program.
In order to be eligible for the shared work program, your hours must be reduced between at least 10%, but no more than 40%. If only your pay is being reduced, then no, you would not be eligible for the shared work program. For salaried employees, their hours and their pay have to be reduced between 10 to 40%, their hours 10 to 40% with the pay also being reduced. Of course, that's in conjunction with what the federal government allows for exempt and salaried employees as far as their reduction in pay. There's some circumstances where you can reduce their pay because there's no work, and there's certain circumstances where you cannot.
Okay. Ryan Rea has a question. It seems like the online login for employer response to notice of unemployment is down. What is the timeline for that to be back up?
There has been some intermittent issues, but please go back in. We had a lot of fixes that were put in over the weekend, and it should be back up and running. If you're still having problems, then please send us an email to the address that I named, and we'll contact you back. But that application should be working now.
Okay. This question says, I received a notice of application for unemployment benefits dated March 30th with a respond by date of April 13th, but then received a determination on payment of unemployment benefits for the same employee dated April 3rd. It looks like the TWC is moving quickly with determination even before the respond by date for employers. Is this because the reason is related to COVID-19 disaster?
That is correct.
Okay. And then I would assume that if needed, that employer can appeal a decision if.
Yes, the employer can appeal, and if the employer response brings up an issue that was not COVID-19 related, the investigation is opened at that time.
Okay.
We still have to instill integrity in the system. So any issues that someone is aware of, please bring it to our attention, and we will investigate those on a case-by-case basis.
Great. Jenny Boyd has a question. You mentioned that employers can sign up to receive notices of unemployment by email rather than regular mail. Where do we go to do that? I'm not seeing this option on the TWC site.
On our employer benefits services site, when you sign up to that site, one of the first questions it asks you, would you like to sign up for electronic correspondence?
Okay. Thank you, everyone, for submitting these questions. They keep rolling in, so we appreciate it. Carol Dunnigan has a question. We have reduced our non-exempt and exempt employees' salaries by 10 to 15%. We did not reduce their hours. Would they be eligible for unemployment for this pay reduction? The reduction in pay was done due to COVID-19 impact on our business.
Are they still working full time, or we can't ask them back a question? Can we get some clarification, or you just received the question as is?
Carol, if you could give a little clarification in the chat function, and it looks like she responded yes. They are still working full-time?
If you're working full-time, you would not be eligible for unemployment benefits.
So you have to have the hour reduction. Is that correct? That's the key.
Well, that's on shared work. It didn't sound like she was asking about shared work. Did it say shared work in there, or maybe repeat the question to us?
No, I'm just trying to clarify if an employer has a reduction of hours, that may be eligible for unemployment, but you're saying just a reduction in pay with no reduction in hours would not be eligible for unemployment.
That is correct. If they're working their customary full-time hours, then they are not eligible for unemployment benefits.
Okay. Let's see. Is the extra $600 a week available only through July? What is the timeline for this extra benefit?
13 weeks.
The extra $600 is available, like you said, through July, and from the time that the contract beginning after the date of the signed agreement through July 31st of 2020. The agreement that Texas made with the Department of Labor. So at the present time, we are trying to implement it to get out the $600 to all applicants who may be qualified for it. But it does end on July 31st of 2020.
Okay. We're getting a number of people saying that the email address, UI Ombudsman, OMBUDSMEN @twc.state.tx.us is not working. So can you just confirm that that is the correct email address?
That's what I'm showing. Could someone try real quick an A instead of an E in ombudsman? And I'll check somewhere else also, but it could be ombudsman, M-A-N instead of M-E-N. But we're checking here on our end, and we'll come back before the end and verify that. but we're going to send it a test one here from ours as well.
Okay, it looks like we had one person respond that it is ombudsman with an A. So we will double check that email address and confirm that before the call ends.
Okay, thank you. We're double checking it here also, that it may be an A instead of an E.
Okay, thank you. So the $600 benefit, we have a question. Do all unemployment workers, W-2, 1099, and self-employed qualify for the $600 or only 1099 and self-employed?
It's available, the $600 is available to both groups. It's available for W-2 workers as well as 1099 and self-employed.
Okay. Another question about the $600 per week from Beth Paul. Just to clarify, anyone that applies for unemployment will qualify for their calculated unemployment benefit plus the $600 per week. Is that correct?
The $600 per week is an additional benefit that would be on top of the person's regular unemployment benefits.
Okay. And will that come in one check, their regular unemployment plus the $600, or will those payments come separately?
We are still programming it, but the goal is for it to be one payment made. We use direct deposit or debit card, no checks.
Okay.
Unless, of course, their direct deposit is still pending.
Yes, if there is some reason it's not working yet.
That email is wasn't paid.
We did verify on that email address. I will read it with an A, U-I-O-M, B like Bravo, U-D, S like Sam, M, A like Apple, N like Nancy, at twc.state.tx.us. And thank you so much for bringing that to our attention.
Okay. We have a question from, let's see, Laura Wiggins at 132. What kind of assistance is available to real estate agents or sole proprietors?
Self-employed, it's the same as self-employed individuals. You would simply go online or call us. We're trying to get everyone as much as possible to go online to our applications, fill out the unemployment benefits application, and you, like I said, you will get an initial notice that says you're monetarily not eligible, but we will reach out to you to get that additional information, which will be proof, such as your tax return for 2019, or any documents that you have that will demonstrate the earnings that you had as far as the profits are concerned.
Thank you. Betsy Harnage had a question about what is the email used for that we've been giving that email address. Just to clarify, that is an alternative for the 1-800 number. Is that correct?
No, it was a question that came up. Someone said, if I can't get through, it was what was it? Employer asked on the.
The question was when and she said that she was being charged for the unemployment benefits because the person indicated they was laid off due to lack of work, and even though she indicated it was due to COVID-19, she was still charged.
That's right.
Okay, and that's just an alternative way that they can make clarifying comments. I think the question was, what are we using that email address for, the ombudsman email address?
In the event that, and the 1-800 number that was being referred to was the 1-800 number that employers are given on the front of the notice of unemployment insurance, where only employers call into our unemployment centers to talk to an agent about their response. But if case that is not working or is busy, then the UI ombudsman was an alternative email that you can send, and they will look into it and refer it to the proper department.
There is a specific 800 number on the employer's notices. That is not the general number that is put out to all workers. There is a specific 1-800 assigned to employers that's on the notice that they receive that states someone has filed a claim.
Okay. We're going to go up earlier in the questions. We had a question that came in on Friday, March 13th. Governor Greg Abbott declared a disaster relating to the pandemic. Therefore, employer tax accounts may be protected from chargeback. Under section 204.022, exclusions from chargebacks, it talks about the chargeback exclusion. What is not clear is, does that work the same for reimbursing employers? If so, do you know if it will all be covered, or what percentage the reimbursing employer will have to cover?
Yes, this was asked earlier in the series. At this time, reimbursing employer accounts are not protected. That is something that's being looked at, protection for them, but that is separate from regular covered employers that have routinely paid every quarter into the unemployment tax program, where they pay a set percent on their workers every quarter. That is different than reimbursing employers. Reimbursing employers would not be paying a payroll tax every quarter. They only pay when a claim is filed, and if the person qualifies, then they receive a bill from us. So that particular group at this time does not fall within the employers that are covered or exempt from any type of chargeback. But laws are being created as we go, different bills, as you've seen through the CARES bill. So I'm not saying that that will be forever. There could be a percentage that's protected, or it could be all. But at this time, reimbursing employers are not covered.
So many questions here, so thank you very much. I know we've repeated some things. I think they've been worded a little differently, but I know for a lot of us, these can be somewhat confusing topics. So I appreciate you taking the time to clarify.
No problem at all.
So this question said, I thought I heard this earlier, but to confirm, 1099 and self-employed workers are only eligible to the $600 federal dollars and not any normal state benefits. If that's the case, what's the income verification used for?
That is correct. The income verification is to substantiate that you were self-employed, or that you were a contract labor, that you were doing some type of work.
We have another shared work question from Wendy Chang. Shared work, is this benefit in addition to regular unemployment benefits a reduced hour employee would receive?
Shared work is a regular unemployment program. It's just under a hourly shared work reduced hours. So you don't get regular unemployment benefits and shared work benefits. It's all unemployment benefits, just under a different format. So they would only get one payment from state unemployment benefits through the shared work program, and then they will get the federal subsidy of the $600 on top of that.
Yes, it's shared work is simply an alternative for employers that are trying to keep their workforce. They may just, as Angela said, reduce X number of hours, but they have not completely separated that person. So shared work is a smaller subset of unemployment benefits that only some employers will sign up for.
Perla Adam is asking a clarifying question. Can you confirm exempt employees who have reduced hours but not pay reductions would not be eligible for unemployment benefits?
That is correct.
It looks like we might still be having some issues with the email address, so we're going to try to confirm that.
We've checked it.
Yeah, it's got them listed both ways.
It's got it listed both ways,
Yeah.
and it's coming. It's checking out on our end. We've got a laptop here that we're testing it with.
Okay.
So let me say the letters and say a word for the letters. Maybe that's it. Okay. UI, so that's uncle, and then I like India. Dot, O like Oscar, M like Mary, B like Bravo, U like umbrella, D like David, S like Samantha, M like Mary, E like Edward, N like Nancy. I'm sorry. Oh, it is coming up as E or A. Oh, it is coming up as M-E-N or M-A-N. We just checked that. So M-A-N or M-E-N on our end is working. At TWC, that's T like Texas, W like window, C like Charlie, dot state, S like Sam, T like tomorrow, A like apple, T like tomorrow, E like Edward, dot T like Tom, X like X-ray, dot U like umbrella, S like Samantha. So UI dot ombudsman or ombudsman at twc.state.tx.us.
Thank you.
And please try it again. We'll get it right before this is over. Yeah, I'm not sure what we did wrong there.
Okay, I have W-2 employees that have applied for unemployment. This is from Karen Raybould, and they have been denied for lack of wages earned. They were laid off due to COVID-19. Can they reapply for COVID-19 benefits?
Can you repeat that? I'm
Sure.
sorry.
I have W-2 employees that have applied for unemployment and have been denied for lack of wages earned. They were laid off due to COVID-19. Can they reapply for COVID-19 benefits?
Yes, I suspect some of those could be because the quarter changed. This past week, April just got here. Our quarters change every quarter. So April would be the beginning of a new quarter. So if anyone applied in March and they received a notice that said they did not, and this is for W-2 workers, if they received a notice that said that they were not monetarily eligible because they did not have enough funds in the base period, they should try again now that April is here because that is a new quarter. Therefore, the base period that we look at has added an additional quarter. Whenever someone files for benefits, a base period is established. And what I mean by base period is we look at the first 4 of the last 5 completed calendar quarters. And that's what we make our calculation on to determine how much unemployment benefits an individual will qualify for. So for example, this past March, last month, when someone applied for benefits, at that time, the first 4 of the last 5 completed calendar quarters or the base period would have covered, let's see, it would have covered October 1 of 2018 through September 30th of 2019. That would have been the base period that we would have determined or made our calculation on to determine how much they would qualify for weekly. Now that we're in April, the quarter has moved down. So we would be looking at all of 2019. So now the base period is January 1st, 2019 through December 31st of 2019. So that base period changes every quarter.
Okay.
But it is set in place. Once a person files, their claim is set in place for that year. So again, if they were disqualified for that reason, try again in the next quarter. And if you still don't qualify because you just didn't have enough earnings to do so, then you can still go ahead and leave the application in, because we will reach out to you for the federal pandemic funds, which is the $600 of federal monies. So if you don't qualify for the state benefits, we can move you over to that one for the $600.
Okay. So we have time for just one more question. How much of a delay can employees plan on before receiving their first unemployment payment? Do you know kind of what the timeline is right now?
About 3. From when you file your initial claim, it's a little over 3 weeks, about 3.5 weeks, I would say, to get your first payment. And then after that, it's every other week, as long as you continue to file your claims every 2 weeks.
Well, thank you so much. I'm going to turn things back over to Quillan at this time.
Thank you.
I'd like to thank Kim and our panel of speakers, Angela, Jerry, and Lachey, and the Austin Chamber team who helped put all this together. Thank you everyone for joining us on this webinar, which we will also share later. And please go to the Austin Chamber events website for future PowerUp webinars that we have scheduled in the coming weeks, and have a good rest of the day. Thank you, everyone.